Thank you, Don. I deeply appreciate that overly generous introduction, and I'm thrilled to be here tonight. This is a remarkable occasion, and it's an honor to be asked to be a part of it. I have to thank Don, as I said, for a great introduction and for the marvelous job he did of selection. Many of them in the room here today. The confirmation process, as we all know, is challenging these days, to put it mildly. And the only way we were able to prevail, obviously, was to have truly talented, well-qualified nominees. And even with them, as you recall, during the last administration, almost all of these talented men and women were on party line vote. Party line vote. This was not a period of collegial confirmations, shall I say. Don was also an outstanding chairman of the Federal Election Commission and ranks right up there with Boyd and Gray, of course, as a terrific White House counsel. Well, I'm here at 2nd Massachusetts. I want to take a moment to applaud and congratulate Kay Cole James. Thank you for your service. And welcome Kevin Roberts as well. So look, I'd like your indulgence to begin tonight with something that is pretty rare for me and perhaps a little out of character. A moment of personal vulnerability. Like the two men we are honoring this evening, Justice Thomas and Judge Silberman, I'm not known for being easily intimidated. And yet I have to say, delivering a keynote lecture on the legacy of a legal titan before this current crowd of genius lawyers, after a full day of expert discussions, it makes for something of an intimidating assignment. I mean, look at it this way. What could I, Mitch McConnell, possibly know about a notable leader who is parsimonious with his public statements? Who shuns the performative aspect of public life? And who is viewed as a boogeyman by the radical left? What would I know about that? Like all of you, I too graduated from law school, but actually that's where our paths diverged. I've been fortunate to be in the presence of a number of talented lawyers over the years, actually none more talented than when I was young, and in a lowly staff position down at DOJ at the time when Lawrence Silberman was Deputy Attorney General. Robert Bork was the solicitor, and Nino Scalia was head of the Office of Legal Counsel. So for a while, I got invited to the staff meetings. You know, for a guy that I wouldn't recommend you go to write a simple will, there I was in the presence of all that legal genius and extraordinary humor. And so, Larry, you got me off to a good start. And by the way, ironically, Larry's sister lives in Louisville, Kentucky. Been a longtime friend of mine and is part of our football tailgating group. So congratulations, Larry, on winning this award. A piece of trivia you may not know, I did produce actually one published legal scholarship before I completely went in a different direction. It was way back in 1970. The outlet was the Kentucky Law Journal. And at the wise old age of 28, I put pen to paper and published a lengthy article on the dry, boring subject of how the U.S. Senate should evaluate nominations to the Supreme Court, and whether at that time they had become too contentious. So thank God the subject has simmered way down since then. It's just sort of been smooth sailing since back in 1970. Actually, the linkage between the Senate and the Supreme Court is a fascinating, crucial, and frankly, slightly strange part of our constitutional order. An institution of our federal government that is sacredly non-political, and another institution that is entirely and intentionally political come crashing together. During some periods, advice and consent was a perfunctory, almost sleepy process. Other times, senators adopted what we might call a more assertive approach. And in some of these latter cases, the confirmation process becomes kind of a referendum on the very same principles and values that the justices are meant to uphold on the bench. The presumption of innocence, due process of law. We all know these subjects are constantly up for discussion in the court. But what's fascinating and disturbing is the frequency with which those very same principles end up on trial across the street on the Senate floor. I was a freshman senator when the far left ate Robert Bork alive in 1987. I'd come to the Senate with a high-minded, perhaps in retrospect rather naive view that I'd expressed in that earlier Law Journal article. The Senate should stick to evaluating nominees' competence and integrity, and let presidents select legal philosophy as they liked. That's what I thought back then. Well, it didn't take long for Ted Kennedy and friends to permanently disabuse me of that rather naive notion. I stood at my freshman's desk in the back row and explained that I'd be happy to play by the Democrats' new rules and make judicial philosophy a salient factor going forward. Let's just say history has a funny way of making people reap what they sow. In 1987, the far left taught the American people they should care a lot about judicial philosophies. In 2013, Harry Reid broke Senate rules to change Senate rules to set the threshold for confirmation at 51. I said at the time, you may be sorry you did this. Neither of those moves played out as colleagues intended. Neither did the disgraceful firestorm that was visited upon Justice Thomas and Ginny back in 1991. Now, I'm not going to dwell on that episode tonight. There's no reason to. We all know what the people behind the smear campaign revealed actually about themselves. But I'll say this, I was inspired then and I'm still inspired today by the courage, the resilience, and the faith which Justice Thomas endured those months and emerged with an appetite for service still intact. The very same grit that carried Clarence through Pinpoint and Savannah, the same stubborn faithfulness that led him ultimately to keep faith in both his church and his country, even after they both let him down in ugly ways as a young black man. The same commitment to principle that compelled Clarence to blaze an uncomfortable trail in Washington, disrupting everybody's expectations. All these virtues proved necessary that summer and fall, and all of them were on display. At every step in his journey, Justice Thomas has provided living proof. As a wise man named Myers Anderson liked to say, old man can't, is dead. He sure is, and Mr. Anderson's grandson, Clarence, helped bury him. You know, it's even more impressive when you remember that this courageous and determined person is also famously one of the most affable, genial, and unself-conscious people in all of Washington. In fact, after watching Justice Thomas excel these 30 years, I'm tempted to propose a new standard here tonight. The Senate should only confirm the kinds of men and women who, when their dramatic final confirmation vote is taking place, decide to turn off the TV and take a bath. We should only confirm people who are happier tailgating out of an RV than rubbing elbows at cocktail parties. That's a standard I could get behind. Of course, the campaign to intimidate and pressure this justice did not stop. Did not stop when the gavel fell. The next year, the still fuming New York Times sneered him as, quote, the youngest, cruelest justice. The hectoring never lets up. But Justice Thomas does not break or bend or bow. This is a particular quality that I want to focus on. This core value of not blinking, not bending, not allowing his judicial office to be compromised by inappropriate bullying from the political sphere. Because I'm concerned that in our current climate, judges all across America will need to study and internalize this quality of Justice Thomas more than at any other time in living memory. Radical voices have a problem with Justice Thomas because he limits his job to his job description. It's not about left or right. It's about our constitutional order itself. Every Justice Thomas opinion evinces a clear understanding that while the role of a judge in our constitutional system is significant and essential, that role is not unbounded. The framers did not create these insulated, unaccountable tribunals for judges to act like wannabe legislators and make policy. Trust me, having two legislative chambers is plenty. Neither should judges behave like philosopher kings who think they're charged with nudging Americans into line with elite morality. And furthermore, and this is especially important in our current climate, judges must not see themselves as political strategists. They're not tasked with reasoning backwards from abstract impressions about what outcomes the nation supposedly needs or the court's public standing supposedly requires. We need the rule of law, not the rule of polls. The judiciary exists to resolve concrete cases and controversies by examining concrete facts and applying concrete texts. That's why Justice Thomas' unapologetically straightforward approach is so needed. Huge parts of Washington exist to overcomplicate things that are simple, but Justice Thomas has a special talent for dispensing with nonsense. Here's one example. By the year 2003, I'd been waging a lengthy political and legal battle against unconstitutional restrictions on the First Amendment that some people call campaign finance reform. We took the fight all the way to the Supreme Court in a case called McConnell versus FEC. Unfortunately, I lost. But Justice Thomas' dissent made for one heck of a consolation prize. He simply, fearlessly called it like he saw it. He blasted the unprecedented restrictions on the free exchange of ideas, a heroic defense of the plain text of the First Amendment. Or take his jurisprudence on unborn life. Every time without fail, Justice Thomas writes a separate, concise opinion to cut through the 50-year tangle of made-up tests and shifting standards and calmly reminds everybody that the whole house of cards lacks a constitutional foundation. Or look at race and equality. I'm a huge fan of my fellow Kentuckian, Justice John Marshall Harlan, the sole dissenter in Plessy versus Ferguson. I would venture that Justice Thomas' jurisprudence displays the clearest, bravest, most straightforwardly colorblind view of race in our Constitution since Harlan himself. He respects the 14th Amendment enough to apply it as it was actually written, a prime example of when it takes courage to let straightforward things be actually straightforward. Doing this work, doing the actual job of a judge, is important and essential enough. Our judiciary has enough to do without reaching outside the Constitution to grab other powers. But radical voices with an agenda to push do not have much patience for this kind of restraint. Today's left is not content to settle for the outcomes that honest textual interpretations can supply. So, my friends, storm clouds are gathering on the horizon. The very concept of an independent and insulated judiciary is actually at stake. A year and a half ago, the Democratic leader in the Senate grabbed a microphone on the Supreme Court steps and threatened two justices by name if they did not rule a way that aligned with his views on abortion. Half a year before that, a whole group of Senate Democrats sent the justices an amicus brief that read like a letter out of The Godfather. Senator Whitehouse and his colleagues wrote, and this is a direct quote from a letter to the court: "The court is not well, and perhaps the court can heal itself before the public demands it be restructured." End quote. These were sitting United States senators essentially saying, nice independent judiciary you've got there, sure would be a shame if something happened to it. Or take this example. This is President Biden's Secretary of State this week in Ecuador giving a speech about democracy. I promise I'm not making this up. The Biden Secretary of State this week making a speech in Ecuador about democracy. He specifically mentioned undermining the independence of the courts and packing courts as two signs that democracy itself is under attack. Let's hear it for the Biden Secretary of State. He obviously hadn't been paying any attention to what's going on in the rest of the administration. This was less than a week after the Democrat pseudo-academic Supreme Court Commission tried a laughably transparent move where they temporarily shelved the idea of outright court packing in order to make the equally shocking concept of eliminating life tenure appear to be like the moderate option. The moderate option. Well, Tony Blinken flies to Latin America to finger wag other nations about pressuring judges while his own boss tries the same trick right here at home. It would be perfect satire if it wasn't so crazy or scary. Again, this is not about conservative policy outcomes versus liberal ones. It runs much deeper. One of our country's two major political movements has decided they're fed up with trying to win the contest of ideas within the institutions the framers left us, and would rather take aim at the institutions themselves. This is the reason why I was so excited to honor Justice Thomas in particular. This is why I'm so encouraged that this new award will bear his name. Because we need a federal judiciary full of men and women who are as bright as Justice Thomas, as expertly trained as Justice Thomas, but most importantly, as committed to total, unflinching judicial independence as Justice Thomas. An institutionalist as Justice Thomas in the truest sense of that word. The future of our nation needs everybody who serves under Article 3 to understand something that Justice Thomas knows better than anyone. Triangulating a moving target while bad actors move the goalposts is a game you lose before you even begin. It does not serve the rule of law to let the loudest, angriest voices define the terms of a debate and then try to invent a halfway point. Hostage takers never settle for half a loaf. There's only one valid response to these efforts to bully impartiality out of America's courtrooms. Give them no corner. Pay them no heed. We need jurists, young and old, whose only response to these blustering threats is to redouble their commitment to follow the law wherever it may lead, with no fear or favor. We need a generation of judges who seek the same two things that Justice Thomas says he prayed for as he walked into his very first conference with his 8 new colleagues. Both the wisdom to know what's right and the courage to do it. Your task may be challenging, I get that, but your oaths demand no less. Your country needs no less. And the good news is that for 30 years and counting, you have had the brightest possible North Star illuminating the path before you. The courage and the fidelity of Justice Clarence Thomas. So, may this happy occasion and this prestigious new award inspire other patriots to follow suit for decades to come. Congratulations to Judge Silberman on this inaugural honor. Justice Thomas, congratulations on 30 years, and thank you. And on behalf of all assembled, at the risk of sounding greedy, we'd like 30 more years.